Welcome back to This Day. Joining me now with Carlson Law is Justin Walley. Welcome. It's your first time being on our show here today. So are you nervous?
Absolutely, yes. Well, thank you for having me on.
Yes, we're so happy to have you here today. So tell me a little bit about yourself, your background. Why did you want to become an attorney?
Well, I wanted to serve my community, and as we were talking about before we started shooting here, I'm a local guy. I grew up in Lake Forest, and I went to college in LA and law school in San Diego, and I like when someone picks up the phone and calls me, and if they have an issue or if they have a goal in mind, and I can use my legal background to help them, that just makes my day, and that's really why I got into it.
And so what would you say has been so far the most rewarding? What is it for you that makes you go, yeah, this is why I come into work?
Yeah, it's providing that peace of mind for people that their estate and their assets that they've spent their life working toward is being protected and is going to pass to the next generation as they intend.
Yeah.
Yeah.
How long have you been with Carlson Law?
So I've been with Ellis Carlson Law since 2019. I've been an attorney for over a decade.
Okay. And now, did you grow up, did your parents, was this things, did your parents talk about financial things, and, was this a family discussion?
Not really, actually, with my parents. I do this for a living, and I kind of had to drag my parents into the office had to prepare their estate plan. It's just something that, for some people, they want to push it off and think about it later, and unfortunately, life transitions that people experience will often trigger them to finally say, okay, I need an estate plan, because I think a large part of it is just the unknown of what is estate planning and why everyone needs an estate plan.
Yeah. Last time Luke Carlson was here, and we definitely talked about why it's important to have an estate plan. And so today with you, we're going to dig a little bit deeper into it and what does it actually entail? What all needs to happen in an estate plan? And so first off, what are the documents that are included that you need to do for an estate plan?
Well, thank you for asking. I like to demystify what estate planning is. So when people come in for a consultation, we do provide complimentary consultation. So if anybody is interested in learning more, they can always call our office and we can schedule a complimentary appointment. And it really is something that people don't know exactly the documents that are included in an estate plan. So typically an estate plan will include a trust, a pour-over will, a healthcare directive, and a power of attorney. And I can talk about the specific purposes for each document if you'd like.
Yeah, I mean, you can give us a little bit kind of generic, general thing. First off, if someone comes in for a consultation, how much time does that take usually?
Depending on each person's specific makeup of their family, if they have a blended family or if they have a lot of assets, it could take anywhere from 30 minutes to an hour typically for the first meeting. Okay.
Yeah. What is the biggest challenge for people to come in to get it done? Why do so many people just put it off?
I think that most people just don't want to think about the inevitable and what will happen. They think, this isn't today's me problem. This is tomorrow me's problem, and that's an easy thing to do. And I think it's just people don't want to think about what will happen, if they were to become incapacitated one day or upon their passing.
And so then going back to the documents that you say, the things that you need to do, so you need to have a trust.
A trust, yes. A trust is greatly important part of an estate plan. It is a legal document or legal instrument that holds and manages your property and provides instructions for what to do with your property, meaning it could be real property, your home, it could be your personal property, it could be a bank account or other financial account that is held in the name of the trust. And it provides instructions for your successor trustees on how to distribute that property to your beneficiaries.
So instructions for your successor trustees.
Yes.
That's for your beneficiaries. That's
yes. There's a lot of
family
kind of
members.
legal terms here.
Okay.
So successor trustees are typically people that you trust that, we often see people naming their children as successor trustees. There are professional trustees out there, or professional fiduciaries, but most often people name a family member or a child to someone that they trust to take over your estate. They can follow the terms, or at least seek legal counsel to help administer the trust after, upon the person who created the trust's incapacity or after they're gone.
So trust was one of the documents. The other one you said the pour-over will?
Sure.
What's a pour-over will?
A pour-over will is another typical part of an estate plan, and it basically, the trust is only good for what is funded into the trust, meaning property that you title in the name of the trust. So anything that's left out of the trust won't be guided by the terms of the trust. So the most often way we see people leave things out of the trust is, they take the steps, they create the trust, they fund the trust, they will transfer the title, of their property into the name of the trust, but then years down the line, they'll inherit some property or they'll inherit a bank account. And when that happens, they might not take that extra step of putting it back into the trust. So the purpose of a pour-over will is it comes into effect at your death, and anything that was inadvertently left out of the trust will be put back into the trust, which would really minimize the probate process for your beneficiaries or heirs. Yeah.
Okay, all right,
Yeah.
that makes sense. And then there was two other things. I believe one was power of attorney, and then what was the
A
other?
healthcare directive.
A health directive.
Those two documents are similar, and a healthcare directive really provides instructions for your family members, your physicians, and anyone else really caring for someone at the end of their life. And you can name agents that will be able to make decisions based on the directives you lay out in the healthcare directive about your end-of-life care. And some people have a healthcare directive with their primary care physician, or a hospital will have one on record. However, we never know where our end-of-life care is going to be, and so we always recommend having one centralized healthcare directive. And that comes into effect when you're still alive but incapacitated. And unfortunately, most people will become incapacitated at some point before they pass. So it's important to have a healthcare directive on file that your agents or your family can get access to, so your wishes can be followed. And a power of attorney is very similar, where you can name agents to act on your behalf if you become incapacitated, but while you're still alive, to handle your financial affairs. So the power of attorney will allow your agents that you name to gain access to your bank accounts, pay bills on your behalf while you're incapacitated, because the last thing anyone wants is bills to go missed while you're incapacitated and just compound the problem.
Right, right. Yeah, definitely makes so much sense. And so what if I'm not particularly wealthy? Do I still need an estate plan?
Yes, we recommend that everyone have an estate plan, because there's a misconception that estate plans and trusts are only for the super wealthy, and that's just not the case. Most people have assets that they hold dear and that they value, and if you don't create an estate plan, there could be unintended consequences, meaning your property could pass, basically the court would step in and decide, what assets you have, and by the statutory law, who those assets should go to. And without an estate plan, your heirs are really gonna have to go through the burden of the probate process, which can take, I think before COVID, it was 18 months to get through probate, and now with the courts being backlogged, it could take even longer.
Wow.
So a properly executed estate plan can help avoid that probate process for your heirs, and it can also prevent your assets from passing to unintended beneficiaries.
Okay. Is it possible to wait too long to have this done, or when is the best time to have it done?
Yes, the best time is right now. California law requires that someone have a mental capacity in order to create an estate plan. So if you wait too long and you become in a position where you don't understand the nature of your family or your heirs or the assets that you own, you wouldn't be able to create an estate plan. And at that point, even if you were to go online and prepare one yourself, it could really be called into question based on someone's capacity if they lack the capacity to properly execute an estate plan. And that's really just doing a disservice to your beneficiaries.
Okay, yeah, well, definitely. Thank you so much, Justin, for being here. Very informative and great advice. I mean, I would say that this is adulting, right?
Yeah, sure.
It's one of those things you don't want to think about. You think you have all the time in the world to do it, but definitely needs to be done, and the sooner the better.
Yeah, absolutely.
So, well, all right, thank you for being here. Appreciate it. Stay with us because we will have more coming up on This Day right after this.